the Chief Justice nominee, Justice Gertrude Araba Esaba Torkonoo, would be true to her publicly professed textualist approach to constitutional interpretation. Whilst the clear language of the Constitution was dealing with qualification to be a member of Parliament, the Supreme Court veered off and was dealing with eligibility or qualification of a person to contest as a member of Parliament. I'm quoting the Supreme Court directly in their reasoning. They actually used that. They said, we are dealing with eligibility or qualification of a person to contest as a member of Parliament. But the Supreme Court talks about qualification to be a member of Parliament. It is after the contest that you then get sworn in to be a member of Parliament. Article 94 is not talking about eligibility to contest elections. It is about becoming a member of Parliament. This only takes place at the point of swearing in. Instead of fidelity to the text of the Constitution, which the CJ nominee professed as a preferred approach to constitutional interpretation, she succumbed to what we believe was a flawed precedent set earlier by the Supreme Court in the ex parte Zaneto case. That is the Republic versus High Court, General Jurisdiction, Accra, ex parte Zaneto Rawlings, Ashite, and National Democratic Congress Interested Parties, number 2 of 2015 to 2016, 1 Supreme Court Ghana Law Report, page 92, which this current court relied on, was wrongly decided by an earlier panel of the Supreme Court. Zaneto would have been qualified anyway if the Supreme Court was to conclude that Article 94 deals with qualification to be a member of Parliament. She would have been qualified anyway if they had adopted the position that we're adopting today, and not eligibility to contest elections to be a member of Parliament, which was what was in issue in the Zaneto case. In the Zaneto case, it was eligibility to contest, because the matter was before the contest. If even we admit that there should be some housekeeping matters at the point of filing nomination papers, that should be the appropriate province of legislation and not judicial enactment. What they did was to enact laws, the Supreme Court, not to interpret the text of the Constitution of Ghana. James Jachikwesin is gearing up to contest the by-election in Asin North, which has been brought about by the Supreme Court's decision. In that regard, we, the members of the Appointments Committee representing the National Democratic Congress, NDC, will not withhold our approval of the Chief Justice nominee by consensus. We will not withhold our approval of her by consensus. Her CV reveals a person of considerable experience, having served as a judge from the High Court to the Court of Appeal and ultimately at the Supreme Court. Women who have acquitted themselves should be given opportunities to occupy key national offices. Even as we disagree with her jurisprudence, we find her qualified to occupy the high office of Chief Justice of the Republic of Ghana.